Well, hello there, Philippine Nurse listeners and followers. How are you all doing today? We hope you are all doing well and thriving in this summer heat. Well, thank you so much for joining us today. And as you know, Philippine Nurse is brought to you by the PNANV, or the Philippine Nurses Association of Nevada, in collaboration with PHLV Radio. So in today's episode, we're diving into a topic that doesn't always make headlines, but affects thousands of lives, and that is all about adult guardianship. It is a system assigned to protect those who cannot make decisions for themselves, whether it's due to age or illness or disability. But in Nevada, this system has undergone a major transformation since 2017, reshaping how we care for the vulnerable adults and defend their rights. We will explore in this episode how legal reforms sparked by the public concern and real-life stories have led to a new approach that balances protection and autonomy. So whether you're a healthcare worker or a caregiver or just someone who just wants to understand the system better, please don't touch the dial, tune in. And this will shed light on what guardianship really means, how it's changing, and what it could look like in the future. So today we have invited two young lawyers. Well, I'm old, they're young, in my opinion, anyway, who will explain to us about legal guardianship. So please welcome Attorney Alex Cherup and Attorney Genevieve Galman.
Yes, thank you for having us.
Of course. It's a long time coming.
Yes, it is an honor to be here and to talk about such an important topic.
Yes, very important indeed. So just to give you a little background, Attorney Alex Cherup is the Executive Director of the Nevada Legal Services, the only statewide legal aid, here in Southern Nevada? No, in Nevada, where he leads the efforts to provide free civil legal assistance to low-income and vulnerable individuals across the state. And he is licensed to practice in Nevada and in New Mexico, right? And Alex brings years of experience in legal advocacy and nonprofit leadership in his role, and his work is focused on eviction defense and guardianship, right? Very good. So he's originally from Michigan and moved to Las Vegas in 2008.
2008.
I'm
a full-time Nevadan now.
Yeah. It's more fun here. I always say that.
Couldn't agree more.
And he has remained, committed to the community. So, Alex, do you have anything to add to that?
Thank you for the opportunity to be here. At Nevada Legal Services, we do practice guardianship law in northern counties in the state. Mm-hmm. And as well, our pro bono project and other attorneys occasionally in-house will represent the petitioner for guardianship in certain circumstances. But my experience has been representing the protected person. The protected person is the individual who is under a guardianship. And so that's what we're going to talk about today.
Yes, it is. Okay, well, let's turn to Ms. Genevieve Galman here. So, Attorney Genevieve Galman is the Assistant Director of the Pro Bono Project of the Legal Aid Services of Legal Aid Center of Southern Nevada. And as Assistant Director, she coordinates care or case placements and handles cases from the Children's Attorney Project, right?
Yes.
And also the Family Justice Project, the Guardianship Advocacy Project, you're a busy gal, and Immigration Advocacy Project, and the Resiliency and Justice Center and Family Law. So, Genevieve has joined the Legal Aid Center of Southern Nevada in 2023 as a full-time attorney, and so she is doing a lot of work. Genevieve, do you have anything to add to that?
Yes, thank you again for having us. It's an honor to be on this panel with Alex, who I've gotten to know through our legal community and our work doing legal aid. And so, yeah, I started out at Legal Aid Center as a guardianship attorney representing the proposed protected person, so specifically in our adult guardianship programs, and I really enjoyed what I did. And so now I am the assistant director of the Pro Bono Project, where I work with all of our units at my firm to place pro bono cases with private attorneys in our community.
Cool. And you just moved from California too, right?
I did, yeah. I moved here several years ago from the Bay Area, but being so close to Vegas, I came here every year. I do have relatives here. My parents retired here, and so so even though it's been a few years, Vegas is home to me.
Is home to you.
Yeah.
Okay, that's good. Well, we're glad you're full time here now, and you too.
Yes.
Mr. Michigan. But anyway, that's good. So this is a very important topic, and it's been a long time coming that we've actually wanted to discuss this. So tell us, and feel free to gang up on it, whoever wants to ask or answer this question. So what is the definition of a guardian?
Yes, so a guardian is a person who has legal authority to make decisions on someone's behalf. And so the court will appoint a guardian in certain situations, and the person who the guardianship is appointed over is called the proposed protected person.
Proposed protected person.
Yes.
Okay.
And so in regards to adults, if there is an adult who is unable to make decisions and take care of himself or herself due to a mental or physical illness, then the court may appoint a guardian to help make decisions on behalf of that person.
Yes.
Okay, very good.
And the determination for if an individual requires a guardian is made by a court.
A court.
And
okay.
that determination is made by a standard called clear and convincing evidence that the person lacks capacity. Those are some big legal terms, but at the end of the day, what that means is the court has found by the evidence presented in the petition by the individual who is hoping to be the guardian, that the individual lacks capacity to make their own decisions. Guardianship is what's called substituted decision making. In other words, a structure in which somebody makes a decision for another individual.
Right.
What we will also talk about today is another type of support called supported decision making, in which individuals are able to provide support and the individual who is would be the proposed protected person continues to make the decisions themselves.
Okay. So that is really, so the court has to determine whether a person needs guardianship or not. Is that what you're saying?
Yes.
Okay.
That is made by a district court judge after a petition for guardianship is filed in that court.
Okay. All right. Well, that's, good clarification on that. So are there any different types of guardianships, and are there either permanent or temporary, or can you tell us about that?
Yeah, so there are. So for adults, there's general guardianship, and that would entail so there's a guardianship over that person's over the person, which would mean that the guardian would have a say over personal matters, medical decisions. Then there's guardianship over that person's estate. And so that guardian would have a say in that person's finances and assets, and managing that person's finances. Yeah.
And sometimes there's both guardianship of person and estate.
An estate.
There are also temporary guardianship arrangements for the person or the estate or both that are meant to address immediate emergency needs related to that person's care and decision making.
Okay. So when does the temporary guardianship become permanent?
Well, there are actually two different legal processes.
Okay,
yes,
all right.
One is and oftentimes they do lead into one leads into the other. But a temporary guardianship is for an immediate acute need, and that is a particular petition for emergency temporary guardianship that's filed. A different petition for general guardianship would be required to be filed in addition to. Temporary guardianships can go for 30 or at most 60 days with extensions. Ultimately, at the end of the day, both of these petitions, though, require a physician certificate to be filed to identify that there is a need for the individual to have somebody as guardian.
As guardian. And tell us some specific instances wherein there's going to be a need for temporary guardianship.
Yeah, a common example is a senior who is diagnosed with dementia, and she is no longer able to care for herself. So commonly a child, an adult child, will petition to be her mother's guardian in that situation. And so she would get the paperwork from the Family Law Self-Help Center, which is run by Legal Aid Center of Southern Nevada, which is my firm. And you can get those forms in person at the courthouse, or you can get the forms online. Like Alex said, there's a physician certificate that's required. And if the petitioner doesn't include that, the petition will likely be dismissed without even a hearing, because that is needed to show that this person is incapacitated or needs 24 care supervision and guidance. And so so that is a common example of seniors with dementia. Another one is an adult who is has autism and is unable to care for himself or herself, and so in that situation, usually it's a parent who's petitioning to be the guardian of this adult with disabilities, or maybe an older sibling or a younger sibling. So those are the most common examples I've seen.
Yeah.
Very true. And in general, the decisions that are being made by the guardian are going to be those essential life decisions. There are some restrictions related to those decision-making powers of the guardian that are actually in statute and are sometimes put into the guardianship order as well. Importantly, in Nevada, one of the advancements that we made over the past 10 years is a protected person's Bill of Rights that exists to identify the rights that an individual under guardianship, the protected person, has related to that guardianship. At the end of the day, the guardian has particular rights related to legal capacity, which means that a person under guardianship does lose some rights.
Some rights, yeah. And okay, so this is important for us to bring forward, especially for the healthcare, because when a patient goes into a do not resuscitate, you actually need an order from a physician. So it's the same with guardianship. You need an order from a physician, correct?
Well, it would be determined on what documents are available in that particular situation related to the determinations that were made. In certain circumstances, there might have been a pre-existing, say, advance directive that had been completed by the individual or the individual's wishes were involved. Generally speaking, though, when we're talking about certain types of decisions, those types of decisions will require court involvement in order for that decision to be made. For instance, a determination related to sterilization would require a petition to the court before the guardian would have that ability to make that decision.
Okay, very good. So what is the role of the guardian with respect to healthcare decisions? That has to be outlined?
The healthcare decision-making related to a guardianship would be under the guardianship of the person.
Okay.
That is the, if you're a guardianship of the estate, and only the estate, then healthcare decisions wouldn't be decisions related to the authority of the guardian.
Okay.
Those decisions, though, related to the health and well-being of the individual will be made, unless there are those certain circumstances where there is court involvement necessary, will be made by the guardian. There are other types of guardianships too, like special guardianships or temporary guardianships, where there will be some restrictions and parameters placed. Ultimately, a guardian of the person is the decision maker for those decisions related to healthcare needs.
Okay, totally different from the estate. Okay.
Right.
Do you have anything to add to that?
Yeah, so in regards to advance directives, so there's the power of attorney for medical, for healthcare. And so
healthcare.
if that's in place already, then that will generally supersede the guardianship.
The guardianship.
Now, if there's a situation where the court finds that the agent designated under power of attorney is not fulfilling his or her obligations to manage that person's health and properly, then the court may then decide what to do next. Is it best to have a guardian involved who will better handle this person's healthcare affairs?
Okay. So, what are the alternatives to guardianship? Do we have any?
There are, yeah. So one of them I just mentioned is the power of attorney for healthcare, and so that is something that an individual, a person would it's a legal document that gives someone that you choose to make decisions on your behalf in regards to your health care in the event that you are incapacitated and no longer able to make decisions for yourself. And so that document has to be signed by that person when he or she is capable of understanding what he or she is signing. Yeah. And so that's something that needs to be done in advance. Now, in a situation where there's no power of attorney for health care, and now this person is in the hospital and now, what do you do? This person hasn't designated anybody to manage their healthcare affairs, and so that's when someone from the family or someone close to them could petition to be their guardian in order to be able to make those decisions on that person's behalf.
I had a personal experience with that. My dad, he was still very cognizant and a little bit maybe on the dementia side, but he was living with us, but he fell down and broke his hip. So he ended up in the nursing home, and at the time he was really just out of it. So we didn't have any power of attorney or anything signed, and they did not want us to make any decisions because he now could not make his decisions. So they didn't even give us the opportunity to petition, or we were told. So I think it was the state's decision on what was going to happen to him with regards to his health care. Was that okay?
Well, that's why this podcast is so important, because so many people in our community are not aware of, or not educated, or told what options they have. And so one of those options is to file for guardianship, and people have that right to file a petition with the court so that you can take care of, like in that situation your father. And so and you were saying that you weren't told about that?
No, we were saying they told us that because he has lost his mentation, there was a psychiatrist that went in and he basically said, no, he's incompetent to make any decisions. So at that point, there was no power of attorney. So I'm like, so what do we do? So we were just told that they, the doctors and the state will have to make the decision for them.
And what year was that?
That was about 8 years ago.
Okay, so around the time our reforms were
and that's so important. The reforms Genevieve is referring to are changes to the system that allow for the community and the individuals who are impacted in these circumstances to have the support, the awareness, and the knowledge about how to ensure that decisions are made either by the individual or by those who care about the individual.
Yeah.
One of the other pieces, too, is that guardianship is a state process, state law. So there are circumstances that may exist in other states. If there's a different arrangement that occurred in California or Arizona, that is a different process for guardianship. But in Nevada, we have made fundamental changes to the system that allow individuals, both individuals who are in need of support and individuals who are there to provide the support, to have a structure to be able to be there for those persons. What it sounds like here is a emergency guardianship petition could have been filed. A general guardianship petition could have been filed. There's even a power of attorney for individuals who are experiencing dementia that's written in plain language, so there's a greater understanding for that person to be able to enter into that arrangement. And the reforms that were made in Nevada are fundamentally focused on the preservation of rights.
Yeah.
And the idea of a guardianship is an idea that should be thought of more so on a continuum. On one side, we've got full guardianship, and on the other side, we've got no guardianship. And in between, there's a whole host of different options that are available. And in Nevada, they just keep growing. because we understand in this state that the concept introduced by the disability rights community, nothing about us without us, is so essential. The individual who is the expert is the individual experiencing those life instances. And so the ability of a person to be involved in those decisions and the preservation of the ability of those individuals to make those decisions is paramount.
Well, so you see why my frustration was, because I'm in healthcare, and all of a sudden I did not have the capability to do anything about him, and the care wasn't really what I really expected. But thankfully enough, it was short-lived. But then again, it made me think, why there has to be some kind of a reprieve on this, or some kind of a process in which you're able to. So I'm glad you're saying that this is a reform now. So
it is,
good,
and
good.
these reforms were triggered by all the guardianship scandals across the nation because of oversight and lack of accountability, resulting in judicial errors in granting guardianships that weren't needed. And if guardianships were granted, there was no accountability on the guardians to see if they were actually fulfilling their duty, which opened the doors to abuse and neglect and financial exploitation of vulnerable people. But in your situation, though, that would have been great for you to be to be your father's guardian. And then there's other cases where people take advantage of vulnerable adults. And so that's why, so in 2017 you mentioned, so these reform efforts were led by our incredible executive director Barbara Buckley and my firm Legal Aid Center of Southern Nevada. And so thanks to those reform efforts, now we have a system in place that is helping eliminate unnecessary guardianships, that is helping eliminate abuse, fraud, and exploitation of vulnerable adults. And so I have one of my most memorable cases when I was an adult guardianship attorney was a 75-year-old senior. She was living in a senior home, and her sister petitioned to be her guardian, filed the paperwork, and so I was appointed to be her attorney. And in the petition, the sister claimed that my client was incompetent, she couldn't handle her affairs, she couldn't take care of herself, so she needed to be appointed as her guardian. And then so part of being a guardianship attorney, you visit your client before the hearing. And so I go to visit my client, and I meet her, and what the sister was claiming in the petition was far from what appeared to be true. She was able to, sure, she needed a cane to walk around, but she was able to speak coherently. She was able to take care of herself, it looked like. She had all her finances in order, showed me all her paperwork, and she was like, I am so shocked that my sister petitioned to be my guardian, because one, I don't need one, and two, if I needed a guardian, it wouldn't be her. Because we're estranged. I haven't spoken to her in years. She has emotionally and physically abused me in the past.
Oh, wow.
And she has stolen some of my belongings and my money. And so, no, I don't want a guardian, and I wouldn't want her to be my guardian. And so the sister did not have a physician certificate, which is what Alex mentioned is one of the requirements for the court to consider in granting a guardianship. So the court dismissed the petition. And when I called my client, she just was in tears, crying, like just so grateful. She was so worried for several weeks leading up to this hearing what was going to happen. And when I think of her, I think about people who are in her situation in other states where they don't require the right to an attorney before the judge makes a decision on a guardianship. So if she was living in another state without those protections, oftentimes sometimes judges will grant guardianships without even hearing from the proposed protected person. Wow. And so that's why these reforms have been so important. And I believe to this day, Nevada is the only state that mandates the right to an attorney for guardianship proceedings.
Right. Yeah. And I'm so glad you said that, because I was reading up on this, doing some research on it, and it was, I guess the reforms were set by one of the biggest cases. Well, we can mention her name because it's already, for public knowledge. April Parks, I think, she and her LLC, or she has a corporation, or some kind of an office or a facility wherein, they did guardianships, legal guardianships, and they had 270 fraudulent guardianship applications, or that they were doing. This was unbelievable. How could that even happen? So, and then that's what catapulted the Barbara Buckley actually to create or suggest the reforms for Nevada, correct? And
yes, and that is the power of access to justice and access to counsel. When we think about lawyers, we often think about the corporate lawyer, we often think about the district attorney, and then we often think about the public defender. In criminal matters, there is a guarantee that if you are charged with a crime that might result in jail time, you are appointed an attorney.
An attorney.
In civil matters, for the most part, there is no structure for representation in the same way. But guardianship law, thanks to these reforms, and Barbara Buckley and her amazing team, there has been this incredible change in this state. So, like Genevieve is saying, everybody who is a proposed protected person is appointed an attorney to protect their rights, to make sure not only that the person's rights are preserved, but that the person's wishes are heard in the guardianship proceedings.
Okay.
So a guardianship attorney representing the proposed protected person is not there to make a determination based on the best interest of the person. They are there to represent that individual in whatever their desires are. Even if their desires are not necessarily within their best interest, the power of access to counsel is you have an attorney, just like in any other legal situation, to represent your wishes.
Yes.
So that is a fundamental piece to what makes this powerful. An individual who's a proposed protected person has an attorney that will advocate for what they want and also advocate for the protection of rights and the procedural rights that exist, to make sure there's that physician certificate, to make sure the right people are served and given notice, to make sure that the orders that are involved in the guardianship don't restrict or limit the individual's rights beyond what is permissible.
Yeah, what is permissible. So all of these now, prior to this, it wasn't always the case, right? There was no court-appointed lawyer for the ones who would need guardianship or sought a petition.
Right. So because of these reforms, what was born out of from my office was the Guardianship Advocacy Project. And so Barbara Buckley created that and worked with the courts in order to have a system in place. And that system is, once someone files a petition to be someone's guardian, the court will automatically appoint an attorney from my office to represent the proposed protected person.
Okay.
And so at my office, we have about 25 guardianship attorneys, and each of them have about 200 cases that they're overseeing. And in addition to that, we have our cases that are conflict cases, meaning that there's a conflict, so we can't handle those cases in-house. So that's when the Pro Bono Project steps in, and we go out into the community to other firms and say, hey, we have this conflict adult guardianship case. Can you please take it? Someone needs to represent this vulnerable adult. And so we recruit other attorneys to take on our conflict cases. And so it's really a community effort with our attorneys in representing these vulnerable adults.
That is so awesome.
Definitely a community effort, because one of the conflict cases turned into one of my cases that I took from the Legal Aid Center of Southern Nevada. And every district court in the state has a guardianship part of their court docket. So other organizations throughout the state will be appointed counsel. So for instance, Nevada Legal Services in Humboldt County and Elko County, we are appointed to be the proposed protected person or protected persons counsel. Northern Nevada Legal Aid is in Douglas County, Carson City, and Washoe County. And so this is a statewide effort to ensure that everybody has an attorney.
Wow. So I was going to ask you, is there ever a time wherein you two collaborate? And I guess you just answered that question.
Yes.
That's so good.
We do.
That's so cool.
We're very much a believer in the philosophy of community lawyering, which is the power of engaging community the power of engaging our partners, and the power of speaking to those who are the recipients of our services to allow us to work collaboratively. Community lawyering is lawyers looking beyond just the legal solution. And there's no better practice of law than the guardianship area of law, because a lot of times it feels like we're social workers. A lot of times we need to know more or just as much about resources than the law, just as much about disability rights, self-advocacy, self-determination, high expectations as the statutes that are involved with guardianship law. And by the way, I will say, just to plug the statute, it's Nevada Revised Statute 159.
NRS 159.
NRS 159.
Okay.
And there's another NRS that's important, and that's NRS 162.
162.
That has some of the alternatives to guardianship. 162C is, in fact, the second wave of reforms. And that's the creation of something called a supported decision-making agreement. To take a few step backs, we talk about how a guardianship is formed, what happens, what powers are available to a guardian. We've talked about the limitations on rights that are accompanied when a guardian is appointed. If we take a few step back, we think, well, what is the process to deciding if a guardianship is necessary? Because if rights are taken away, is it best to jump right into guardianship, or should there be other opportunities for individuals to have ways in which rights can be protected? And that's back to that idea of supported decision-making and substituted decision-making. And ultimately, guardianship should be the last resort.
Correct.
Other options are available, and those are those alternatives to guardianship that allow individuals to either remain the decision maker or, in other circumstances, select who they would like without a court involved to make those decisions for them. NRS 162C, with the Supported Decision Making Act, is the representation of a supported decision-making framework which allows, under law, individuals to enter in supported decision-making agreements that contain all of the areas that the individuals identify they need support, and then allow them to select those that they would want to be their supporters. What this means is the individual is able to still make their decisions. And select who they would like to help them with those decisions. No court is involved. All that is necessary under this new law is the individual making the decision that they would like to enter in this supported decision-making agreement, and the selection of those who would like to participate. At that point, rights are preserved and the individual is still able to make those decisions. And that is the reason, as a matter of fact, that I came back to practice law in Nevada. Because I saw that these incredible options were being made available to individuals in this state. And it was July 1st, 2019 that this became law. And it was led by people with disabilities, saying that under guardianship, we lose rights. So what is possible in alternative to guardianship where we can preserve our rights and we can remain the decision maker about the most essential components of our experience?
Very good. So this reform and this law then prevents financial exploitation, neglect, and abuse of the would-be guardians, right?
Yeah, that is the goal. And I just seeing the changes that have happened, and you've been here a little longer than me, so just seeing the changes that have happened since the reforms were started, there has been improvement in Nevada.
Yes. In many circumstances, arrangements related to, for instance, if we think about senior care, when individuals are not able to make self-determined decisions and advocate for themselves and be included in the community and in every aspect of their lives, we see individuals who are going to be in circumstances where there is more of an opportunity for there to be restrictions of rights. And as we see, institutionalized settings are often the source of abuse. We see restrictions of rights themselves as the restriction of the right itself being abuse or leading to abuse. So the disability rights community, which was essential in the creation of this Supported Decision-Making Act, has identified that people with disabilities should be included in society, and people with disabilities should be integrated to the greatest extent possible. And the best way for that to happen is for those individuals to be able to make the decisions about where they would like to be, what they would like to do, and how they would like to live. And if you think about guardianship, if it means the substituted decision making, where somebody else is making the decision, it allows for there to be some distance between that person saying, this is what I want, and this is what my decision is, because there's somebody making that decision for them. So this is what's made Nevada really front and center in these guardianship reforms, is not only the access to counsel, but also the focus on decision making as a right for individuals. Under guardianship, you will lose the right to enter into particular contracts, to make particular decisions. There's even statutes in Nevada guardianship law that allow for the restrictions of firearms, allow for the restrictions related to voting. So this is a process that allows individuals to be front and center in their experiences in life and in their decision
making. Okay. So why hasn't other states considered these reforms?
It's a good question.
I'm so this is great to think that Nevada is front and center on these reforms. It's wonderful.
It is so wonderful to know that we are leading in this area of law. And I will say that there have been several counties, particularly in California, who have reached out to my firm to get some guidance on how they can implement something similar in their counties in regards to guardianship. So I am hopeful that other states will eventually follow, but it needs to happen soon because there's still abuse and exploitation going on all around our country.
Oh, yeah, we hear it every day. We hear it every day, from patients and from other people who may be involved in the care of a person saying, oh, this guardian has basically looted the money, the financial, aspects of this individual, and so many other things that. And I'm just so glad we're doing this podcast to, create awareness,
Absolutely.
out there.
And what has helped prevent exploitation and abuse and neglect is when someone is appointed a guardian, you're not just on your own. The court is watching. Meaning you do have to submit yearly paperwork to show that you are fulfilling your obligations as this person's guardian. And when it comes to someone's finances or even more paperwork that you have to show, you can't just take the protected person's money and spend it however you want. You have to show that you are using it for the right reasons in regards to caring for for the protected person. And so that's one of the great reforms that we've had is having accountability with the guardians.
So there is continued oversight then of the courts.
By the court, and there's also the attorneys that are appointed from my firm to represent the protected persons. They are that person's attorney for life, or until that person becomes regains their capacity to make decisions. But most of the time, the representation will end once they pass away. So these attorneys can be representing them for decades.
For decades, yeah. Okay, so what is the paperwork that is required to become a guardian? Is there?
Yeah, so there are separate paperwork for adult guardianship and guardianship over children, and so there's certain requirements for each. So I encourage anyone who's interested in filing for guardianship to go to the Family Law Self-Help Center, which is located in the Family Court on Pecos in downtown Las Vegas. And so there you can get all the paperwork, all the requirements, and you can even ask for guidance and to make sure that you as a petitioner are fulfilling all the paperwork you need to properly. And I get asked this question by potential guardians, like, do I need to hire counsel to file paperwork to be someone's guardian? I mean, it is always advisable to get legal guidance when you are submitting paperwork to the court. And so it's not required, but it is encouraged to do that. And Alex, you mentioned that sometimes you guys represent petitioners.
Yes, absolutely. So individuals can visit our website and complete an online intake if they are looking for counsel and advice or potentially representation related to petitioning for guardianship, whether it be of an adult or of a minor. That is a complicated process.
Yes.
And I was looking through the requirements in preparation for today because Genevieve and I are attorneys who represent the proposed protected person.
Okay.
So we generally, there's been a couple of times where I've represented the guardian in the petition. And, but it's not the everyday
Scenario.
component of our practice. We're usually looking through the petition and saying, is that requirement met? Did they do, where's the citation? All those different pieces of the requirements. But when it comes to petitioning for guardianship, in addition to all of the documentation, the petition, the citation that's then identified as far as when the court hearing is going to occur, it's important that the correct individuals are served. Service is one of the most frequent issues related to filing a petition for guardianship. In other words, individuals who are involved in the person's life who need to be notified about this change because the statute says this is important for those individuals to be notified. And those service requirements are very important to the court too. So you might, if you don't serve the right individuals or do not have the documentation to demonstrate that you serve those individuals, then the hearing for the petition for guardianship might be continued or denied based on that particular piece. And one of the important items in service is if an individual is the proposed protected person and somebody's petitioning for guardianship, you got to make sure that you personally serve the person who would be the proposed protected person. So that is to make sure that the individual has a copy of that petition because that person is going to be in court potentially with a guardianship hearing and needs to know about that. Also, those within a second degree of consanguinity. And the Legal Aid Family Law Self-Help Center resource is fantastic. It goes through point by point who is included in the service requirements. So we're talking parents, we're talking grandparents, we're talking children, we're talking brothers and sisters. We're also talking about individuals who might be involved in the care. So if the individual receives Medicaid benefits, then the petitioner for the guardianship has to include the office that's involved in those benefits, Health and Human Services, in that service. If a person has veterans benefits, the Veterans Administration. Also, if a person lives in a long-term care facility or a skilled nursing facility, those individuals would also need to be served. So it's a very important component. And just to plug the great work of the Legal Aid Center of Southern Nevada.
Collaborating always.
Collaborating right here. I don't know if folks can see it on the camera right there, but this is the Guardianship Community Education, Legal Education Class Attendee Manual. There is a session that is delivered by folks at the Boyd School of Law and legal aid organizations in the state. And this resource walks through everything that we're talking about. And I just look at the table of contents: guardianship and guardians, how to become a guardian, the guardianship hearing, responsibilities after the hearing. Everything is in here, and it's presented in a way that's easily accessible for individuals who need the information.
So to the audience, by the way, this is such a topic that has so many components to it, and we don't really have the time for this hour to talk about your organization. So we are going to invite them for a second podcast recording, actually, or no, you'll be appearing on another podcast to discuss the works of the Legal Aid Center of Southern Nevada and also the Nevada Legal Aid. So that's in Filipino, abangan ang susunod na kabanata, meaning stay tuned. Alex?
Yes.
Okay, so I have a couple more questions about guardianship. So what happens if the patient has an advance directive? What happens with that? If they have a guardian appointed, but they also have an advance directive, what happens?
Yeah, so it depends. So if there is, for example, a power of attorney for healthcare or finances already in place, and someone is filing to be that person's guardian who's not the designated agent listed in the power of attorney documents, then, like I mentioned earlier, generally the courts will recognize the power of attorney documents because those documents were made at the time this person was capable of making decisions, and he or she already designated someone to take care of her healthcare or finances. So that's, but again, if the court finds that the designated agent is not fulfilling his or her duties under those legal documents, then the court may consider appointing someone else who's better suited, for example, another person to be the guardian in that situation.
Okay.
Yes. And to build on what Genevieve is saying, if there's a power of attorney for healthcare decisions or a power of attorney for financial decisions or an advance directive, then a guardianship may not be necessary. In other words, a power of attorney is an alternative to guardianship.
I see.
If you've got a power of attorney for healthcare decisions and that power of attorney is in place, then that is a good reason for the judge to say a guardianship is not necessary, or a good reason for family members to not petition for guardianship at all, because that power of attorney is able to accomplish those healthcare decisions. And the individual, what's beautiful about the powers of attorney is the individual identifies and nominates who they would like to be their agents to make those decisions.
Right.
Another part about this too, related to powers of attorney, is there's two types of powers of attorney. There's durable powers of attorney that go into effect when signed, and then there's springing powers of attorney that go into effect if capacity were to be lost. So those are decisions that individuals can make about their needs proactively that can create structures that mean guardianship may not be necessary at any point because these documents will provide those alternatives. We talked about the power of attorney as an alternative to guardianship related to those who have dementia. There also is a power of attorney, and this is actually 2015 this law was changed, also led by the disability rights community, that allows for individuals who have intellectual disabilities to be able to access the power of attorney structure for healthcare decisions. And the form is in plain language that individuals who have intellectual disabilities are able to understand in more depth. Though that form then allows an individual with an intellectual disability to create a power of attorney for healthcare decisions, which means that a guardianship in those circumstances will likely not be necessary. And why that's important is Genevieve was talking about the duration of a guardianship. Oftentimes it does continue for many, many years, decades, in a lot of circumstances up to the death of the protected person. Powers of attorney for healthcare decisions for individuals with intellectual disabilities or anyone else who enters into those arrangements means that an individual who has a disability, who is 20 years old, 30 years old, 40 years old, will have a structure that will allow for that individual to still make their decisions. And think about it, we could incorporate that supported decision-making agreement that a person can enter to say, hey, here is who I would like to help me with decisions. And supported decision-making decisions in a supported decision-making agreement, those can be decisions about healthcare, where to live, dating, finances, just about everything can be included in that supported decision-making agreement.
Really?
Yes, yeah. the social experiences.
Okay.
Yeah. And I actually brought with me, and these are available online too, some resources that show how you can create these supported decision-making agreements. And all you really need is an individual, supporters, 2 witnesses, notary isn't even required under law, and an outline of the decisions that a person who is in a supported decision-making agreement, who is called a principal, can identify that they would like their supporters to help them with. And if we have a supported decision-making agreement and a power of attorney for healthcare decisions, and maybe a power of attorney for financial decisions, or another alternative to guardianship we haven't talked about yet, a representative payee, individuals who have Social Security Administration benefits, there often isn't a representative payee appointed by the Social Security Administration that allows for individuals to have support with those funds, which also can be in place of a guardian. So with all these different alternatives that can be used together, individuals who otherwise would have a guardian are now able to remain the decision maker in their lives.
Very good.
Yeah, and so that's why we encourage families to plan ahead and to do what you can, and we really encourage looking at these alternatives before even considering a guardianship.
Very good.
Yeah.
Well, this was really very enlightening. And so what is your message to the public about guardianship, legal guardianship? Who wants to start?
Yeah, so my message, I basically said it just a few minutes ago, but just to explore the alternatives in regards to your situations before you file a petition to be a guardian, and consult everyone who's involved in your family beforehand. It will make it so much easier for you all to get on the same page once you discuss all the alternatives available to you. And I know we talked about so many different requirements on how to go about these options, and so I encourage you to check out the Family Law Self-Help Center website, which includes all of the resources that Alex and I talked about today. And the Legal Aid Center of Southern Nevada website also has the education classes, the manuals, all about adult guardianship. And so all the resources are available there to you, and I encourage you to share them with your family and friends, because most people don't know about guardianship. They don't know about even estate planning, that you can plan ahead, and you can, and planning ahead is just, you want to be preventative, right?
Yes.
Just like with healthcare. It's all about being preventative as much as possible, and that starts with knowledge and resources. So thank you for having us here to talk about guardianship, and I hope that people out there learned something new today.
I bet they did. Alex, what is your message to the public?
My message, Genevieve just said it so beautifully. Guardianship is the last resort.
Yeah.
There are so many other steps that families and individuals can take prior to filing a petition for guardianship that will allow for individuals to remain their decision makers while receiving the support that they need. And like I said, nothing about us without us. That is the mantra of the disability rights community, and is essential when we think about decision making when it comes to individuals. So look at those other alternatives. There are circumstances, as we've identified, where guardianship is necessary. But by looking at these large number of alternatives to guardianship, you might just find those supports that fit your needs best. And at the end of the day, all of this information is available on the Legal Aid Self-Help Family Law Center website. There's a statewide guardianship self-help structure as well that is available online. And there are also resources that are available on a website for supported decision-making in Nevada that was funded by the Governor's Council on Developmental Disabilities, that allows you to look at all of the alternatives to guardianship and give you the tools that you need to be able to look at what is best for your needs.
Wow. Well, Mr. Alex Cherup and Genevieve Galman, we thank you very much for joining us today and talking to us and explaining to us about legal guardianship. It's a lot of people out there don't know much about this, and I'm so glad that you came here and talked about it. So, as we did not have time to talk about the organizations that you work for, we are bringing you back to talk about the legal aid in Nevada And so, would that be okay?
We
Absolutely,
can't wait.
yeah.
Looking forward to it.
Okay. And to our Philippine NARS audience, we leave you with this. In 2017, Nevada responded to a high-profile guardianship scandals actually, by overhauling its system. The state now mandates that independent attorneys have to be assigned to represent adults whenever a guardianship petition is filed, and most of them no cost, right? At no cost. So this mirrors the principle in criminal law where an indigent defendant or indigent defendants are entitled to free counsel. While most states claim to uphold the right to counsel in guardianship cases, Nevada sets a higher bar. Representation must begin before the petition is approved, and the attorney's sole duty is to advocate for the adult's interests, and legal fees are covered by the court. So this reform is pretty visible here in our community in Clark County, which is home to some over 2 million residents, where legal aid and attorneys rigorously review the guardianship petitions before they are approved. So the results are meaningful, and the advocates across the country are urging other states to follow Nevada's lead. So thank you so much for joining us today in this very important journey into the world of attorney or adult guardianship. And as we've seen, Nevada reforms reflect a legal change and support and respect the people who need our care the most. So whether you're in healthcare or advocating for a legal one, advocating for a legal aid for a loved one, I should say, or simply, tuning in to learn, we hope that the conversation we had here today gave you a fresh insight on how guardianship works. So thank you so much for joining us today. Be safe and be well. Until next time, this is Doris Bauer, your Philippine NARS host, signing off for now.
Just like a friend from back home.
This is your Filipino radio experience in Las Vegas. PHLV Radio.